Thank you so much. And there's so many opportunities to do retrospective reviews to help us proactively on all the cases that we've worked on, small, medium, large. And in this room, you know, we have a lot of the players who've been very instrumental, as well as Department of Justice and White House and NOAA, Interior, lots of BP is in the room. We have a lot of people who are very, you know, but very interesting analysis. Thank you so much, John. We appreciate it. So we're now going on, we're going to set up the next panel, which will start imminently. And I'm going to introduce John Deason, who is the moderator of this panel. We have quite a number of people. And he will introduce them very quickly by name, affiliation, and we'll defer you to the online information. But I'm very pleased to welcome you to the podium, Professor Jonathan Deason, who will be guiding us through a session on the current lay of the land where we are in law, science, economics, and policy. We have a terrific panel. In addition to the influences discussed earlier, these developments continue to shape leadership and in the trenches practitioners approach, manage, and resolve natural resource matters at particular sites. John is Executive Director of the Environmental and Energy Management Institute and lead professor of the Environmental and Energy Management Graduate Program at the George Washington University. Again, his full bio is available on our website, and I'm sure that his extended CV is available on the GW website. And I should say that John and I met many years ago when he was actually heading up the Department of Interior Policy Office. And so we go way back. So I think it's kind of interesting that so many of our speakers have done public service and then come to other either private sector or academic. So, and it all enriches how we view this practice arena. So look forward to this panel and thank you all.
Online.
One minute for your speak.
Cool. Okay, good. We need it.
Are you giving them 10 minutes apiece?
I think so, yeah. Yeah. Okay, thank you, Barbara. I'd like to ask the question, where does John Cruden get his energy? I've seen John many times, but every time I see him, he gets better. So thank you, John. All right, so we have, as you can see, we have a lot of panelists. We have one virtually, so we actually have 7 panelists, and so we have to be efficient with our time. And this session has to do with where we are presently. So we have 4 topics, have legal, technical, economic, and policy, and we're just going to proceed in that order, okay? For legal, we have Lauren Daniel, who's an environmental litigator here at Arnold & Palmer. David Kreisner, who's first Assistant Attorney General, Colorado Department of Law. For the second panel, the second topic is technical. We have Bill Goodfellow, who's Director of Exponent's Ecological and Biological Sciences Practice, and Tim Hosley, who's virtual. Tim is Deputy Director, Office of NRD, Department of the Interior, where I used to be. For the third topic, economic, we have Al McGartland first, who is Senior Economic Advisor, National Center for Environmental Economics at EPA, and Ted Tomasi, who is the Senior Principal, Natural Resources and Environmental Economics at Integral. Finally, the fourth topic is policy. We have Ruth Hayes, who's Senior Director of Policy, Global Energy Institute, U.S. Chamber of Commerce. So without further ado, I think I'll turn to Lauren and followed by David to kick us off with the legal topic.
Great. Hi, everybody. Lauren Daniel. I'm a partner here at Arnold & Porter. Just a little bit more about my background. I started my career as one of BP's lawyers in the Deepwater Horizon case. And I think I might be the only member of the defense team from the Deepwater Horizon Clean Water Act trials that's in the room. So I just wanted to, say, first of all, I disagree with some of John's characterizations about the environmental harm arising as a result of the spill. But I was glad to hear you recount that BP got an A as part of its cleanup efforts. I do think that that's incredibly important for all of us to, be aware of and take into account as we move forward in the practice of environmental law and NRD law specifically. I think we need to be thinking about how we can incentivize a response effort like what BP mobilized in response to Deepwater Horizon, because, you can do all the planning in the world, but accidents are going to happen. And we want to create policy that incentivizes that really, full-throated response in the face of potential environmental damage. So, and then I do have my favorite untold story from the Deepwater Horizon trials, which John is not a part of. But we, after the third phase, the penalty phase of the Deepwater Horizon trial, all of the BP lawyers went out to Frenchmen Street in New Orleans to celebrate the end of a very long series of trials. And lo and behold, who did we run into but the Justice Department trial team at a bar on Frenchmen Street, and we proceeded to spend the evening together recounting stories from the trial. So I think that that is just a wonderful story because it, is indicative of how collaborative the environmental bar is. And I think that, this conference is yet another indicator of that. So very happy to be here and speak. Okay, so what I wanted to talk about today is I don't think that there are a ton of legal developments that, in the NRD space that we need to be focused on really intently, but there are a couple. So I'm just going to hit on two, and then I think David's going to take a little bit of a different tack and talk about some different things. But the first thing I think that is probably obvious in terms of legal developments is I think everyone knows that the Department of Interior has a pending rulemaking on its Type A assessments related to natural resource damages. The current Type A regulations have, I think, not been used in many, many, many years because they're essentially irrelevant at this point in time. The repurposing of Type A is actually something that arose out of Deepwater Horizon as well. It is the implementation of one of the lessons learned, which is that early restoration really works. As John mentioned, we have to be focused on restoration as the ultimate goal in NRD cases. And in Deepwater Horizon, one of the really novel things I think that BP and the government did was negotiate early restoration projects where we were able to get money out into the community to start fixing some of the issues that were popping up before liability or damages had been assessed. And that was incredibly effective. Coming out of that, I think that the Type A regulations, I'm not going to take full credit, but Brian Israel and I did a thought piece in EPA Trends that sparked the process to look at how we could repurpose Type A to further encourage early restoration. And that is what is the proposed rule that I guess we'll hear from DOI whether or not it will be promulgated soon. I think that the one thing that I want to say about the proposed rule is that I think that the possibilities are really infinite here. The proposed rule in its current form has a value limit on when you can use the new Type A. They're sort of abbreviated procedures that seek to get to early restoration sooner on a negotiated basis between two parties. And I actually think that we could make new Type A regulations even more impactful and important if we were to expand their applicability to really any scenario. As long as you have a scenario where both parties, the trustees and the PRPs, are agreeing that the process makes sense, I think that you can sort of achieve infinite results in terms of restoring damage that was done more efficiently and sooner. And I think it's important, right, that you have a rebuttable presumption that attaches to that, because while you do have other parties that are interested besides the PRPs and the government, I think that, right, if what our goal is to accomplish as much restoration as early as possible, attaching the rebuttable presumption to that is an important aspect of ensuring that that happens. The other thing that I wanted to mention and just touch on that's an important legal development that I think most folks are aware of is that at the end of 2023, a brand new, not entirely new, just slightly modified Federal Rule of Evidence 702 came into being. For those who are not lawyers or litigators in the room, Federal Rule of Evidence 702 is what governs the admissibility of expert testimony and litigation, and governs what we refer to as Daubert motions. So the changes to the rule are not really changes because the committee notes indicate that they are essentially trying to clarify the pre-existing rule, but it is clear that the thrust of the change in the rule is to encourage courts to more liberally exercise their gatekeeping function under Rule 702. In other words, the goal of the revised rule is to result in more exclusion of expert testimony at the pretrial stage. I think that's really important in the NRD context because what we're talking about in the NRD context is hard science. And I mean, not just hard in that, it's chemistry and biology, et cetera. I mean, hard in that it's very, very difficult, and economics. And the place where I think that the new Rule 702 is perhaps the most important is in the economic space, particularly with respect to sort of the novel economics tools we've seen trustees using to value natural resource damages. So yet another lesson coming out of Deepwater Horizon. We saw in Deepwater Horizon, the trustees spend quite a bit of money doing contingent valuation surveys to assess the economic value of resources that were damaged as a result of the spill. However, none of the contingent valuation surveys that were developed and implemented in response to the spill were actually relied upon in the settlement that was referenced earlier. So I think that's important. It's also important to be aware that there is no court that has relied upon a contingent valuation survey in its damages assessment to date. So all the indications are that contingent valuation is sort of dead on arrival already, but I think that the new Rule 702 is a place where you could really see the judicial branch sort of put the last nail in the coffin of contingent valuation.
Okay, thank you very much, Lauren. So what we're going to do is we're going to run through all 7 panelists, and then we'll have some discussion among the panelists. Then we'll open it up for Q&A for everybody. Okay. So next would be David.
I'm always happy to hear John Cruden talk, but I was especially happy to hear him talk today because I had shown up for a nerds conference and the whole morning, no one talked about nerds. And finally, John is there talking about nerds. So yeah, I have imposter syndrome often enough, but imagine showing up at a conference, being on as a panelist and wondering whether we're really going to talk about what I came to talk about. So thank you, John. Usual disclaimer. What's that? That's right. That's right. So the usual disclaimer, I work for the Colorado Attorney General, but I'm speaking for myself, not the state, not Phil. So I'm going to give you, I'm told to talk about the current state of the practice. I'm going to talk to you about practice in Colorado. And I feel in Colorado like a small fish in a smaller pond, medium-sized pond. Here, I feel like a minnow in the ocean, but nonetheless suffer through this. We are a small state. We are not very industrialized. We have no state Superfund statute, so we go through whatever DOI decides for CERCLA and NOAA decides for OPA. We are dependent on the Fed's listing of PFAS. If that goes away, then we don't have that on the enforcement side, which is basically where I grew up. We do have PFAS as a hazardous constituent under the state regs, but we are a smaller state and we are inland, no coastlines, and therefore that limits some of our damages as well. So we are also odd politically because instead of having a one state bureaucrat be the trustee, we have 3 trustees who meet as a public body. That is the head of Department of Natural Resources, the head of the state version of the EPA, and the Attorney General. So I have my boss's boss as part of a client agency. The trustees meet quarterly, open meetings law applies, et cetera, et cetera. Colorado was a leader in NERDS practice. Back in 1983, when we thought there was a 3-year statute of limitations for Superfund claims. So we brought a bunch of big Superfund claims at disaster sites. They were mostly for cleanup. They also had natural resource damages components, and we fought through those for a long time. And we got millions of dollars, and our trustees have very much enjoyed spending that kind of money on local projects. We require the local governments and local stakeholders to come up with projects. Unlike the federal system, we don't have a long list of things we want to do with money we might collect from various defendants. But instead, we start over at every site where there's been an injury to Colorado's natural resources. We ask for local input. What projects would you like to see? What can you justify for the resources that were injured? Most of our big old cases were federal facilities and mining cases. Again, there's no coastline in Colorado, so we don't have a lot of the same kinds of cases that you all have. We do have oil blowouts. Right now, we are litigating an oil blowout. It wasn't quite the same as Deepwater Horizon. They managed to keep it from igniting, which was a beautiful thing. But we did have almost 5 days of 50-foot geyser of natural gas and oil blowing into the air in Weld County just a few months ago. So we're looking at that particular claim. But I think that's an illustration of the smaller scale of our kind of projects. So I want to talk a little bit about us too. We attorneys who represent natural resources trustees are mostly enforcement trial lawyers, okay? Most of our cases are preliminary injunctions. We are trying to force somebody to do something they don't want to do because it's really expensive to clean chlorinated solvents from groundwater, for example, which is a lot of what we end up doing. We represent that agency all the way from the stakeholder process through rulemakings before the commission. We advise on legislation, and then we do the enforcement, administrative enforcement, district court, all the way to the Colorado Supreme Court, if necessary. And that kind of informs the way that we look at our NERDS claims. I see them as just another opportunity to make a claim against a defendant that will help the state of Colorado. It's usually not injunctive relief, of course. We're just looking for damages. So how does this work for us? We have a simplified administrative process. Lauren referred to the DOI regs. Inside EPA, I think we've lost our reporter, but inside EPA, oh, there she is over there, reported this morning that 4 days ago, the DOI regs went to the White House for final review. Unfortunately, we haven't seen those final regs yet. I guess we don't get to see that until after the White House. But we submitted extensive comments on those DOI regs. I agree with Lauren, and I agree with Lauren's former boss, Brian Israel. I never thought I'd get on the phone with Brian Israel and agree with almost everything he said. But there we were talking about the type A regs, and there was 85% agreement in the kinds of changes that we saw that he and I thought should be made to those proposed by DOI. Let me say, thank you, DOI. The proposed changes are much better than the existing type A regs. But line delivered for shock value, if they are passed as they were proposed, Colorado will not change its processes. We will not use the type A regs. Even as improved as they will be, they're still not as streamlined and useful as our process from my point of view. So that was my big shock line. I think it would be great, though, if there were standardized procedures for coming up with the value of small claims. Colorado looked at coming up with some kind of ticket system, the way Washington and several other states have, and that just didn't seem to be cost effective. Today, we are down to, we're done with the big disaster sites. We've collected the money, we've mostly spent it, and we are making a couple claims a year for gasoline tanker rollovers and aerial crop dusting oversprays and that one oil blowout I talked about. Those are the kinds of cases that we have. We don't have big manufacturing. We're unlikely, thankfully, to have big NPL caliber sites in the future. So we're not going to have, we hope we're not going to have, huge NERDS claims. Our future, and I think the future of many states, is in those smaller day-to-day type of claims, some of which in the past we kind of weren't focused on because we're worried about other sites. So in those smaller cases, I don't see a need for a rebuttable presumption. I go to trial, people that work with me go to trial several times a year or go to hearing for a preliminary injunction, and we're not looking at winning our case by 51%, or is the other side going to, be able to come up with a scintilla of evidence to shift the burden or anything like that. We've got evidence, we've got experts, we've got photographs, and we're going to win the case. And the slight advantage provided by the rebuttable presumption isn't worth as much to me as the efficiency of a useful process for getting to the assessment of injuries and the calculation of damages. I would agree with Lauren. Calculation of those damages, the economics is a little bit of a soft point, but I'd rather fight that out in trial than have an unreasonably cumbersome process on the front end. So I also want to put out a call for, and I'm just saying this because we recently went through the process, a more efficient way to come to cooperative agreements with bigger, more sophisticated defendants would be very useful. We recently entered into a cooperative agreement with a large Fortune 100 company, and we had an example from DOI of a cooperative agreement they'd had with them from the past, and it was not useful. It looked like it had been written by a lawyer who graduated from law school in the 1920s, okay? We started over from scratch. We came up with something in plain English. If there were more plain English cooperative agreements out there that could be used in a standardized way with the more sophisticated defendants, I would welcome that as a retail enforcement and NERDS attorney. Thank you for suffering through my talk.
Okay, thank you, David. That was great. All right, so we'll turn from the legal topic now to the more technical stuff, starting off with Bill.
Thank you. I'm Bill Goodfellow from Exponent, and I want to break this up into two different medias, I guess, or pathways, or whatever you want to call it. So the biological part of natural resources assessments hasn't really changed for the last 2 decades. It's pretty much the same. Toxicologically, it probably hasn't really changed for the last decade. I mean, we're always getting better at it, but it's really the structure hasn't really changed. We're looking at, we have the toxicologically, we have better assessment of more species. not just the three organisms that we normally test over, for that time. We're getting better and better and better at that. I think where the advancements have been on the science side is the analytical chemistry and exposure. And what that has done is it's been an expansion of natural resource damages, really incorporating not just the traditional chemical stressors, but others. For example, we've been talking about climate change. Well, climate change is it's a basket full of stressors, and some of them work against each other, some of them work for each other. So it makes it more challenging to do that when you're doing those assessments. So the traditional techniques aren't necessarily always applicable. Wildfires is a great example. With a chemical stressor, there's a spill or an exposure to a chemical, you see a populational decrease. When a wildfire, it can be a population increase. I mean, you can have the initial damages from the fire, but then within 2 or 3 years, especially out in the high chaparral, you have the biodiversity has increased multiple fold because you've now released a lot of nutrients and chemicals back into the environment that were sequestered for many years. So the traditional tools that we use aren't necessarily always applicable for wildfires. And then we have emerging chemicals, and we've talked about them. I always think of them more as they're really emerging concerns of chemicals, because we have some chemicals that have been in commerce since the 40s, 50s, and 60s that we're calling an emerging chemical. Well, it's not. It's been there for a long time. We're just finally having the analytical ability to detect them in the concentrations that we can do of showing potential harm. We're now, it used to be everything was in the milligram per liter, milligram per kilogram basis. Then we went to, microgram per liter or kilogram. Now we're in the sub nanogram per liter, nanograms per liter or kilogram basis. So we're now having better and better and better techniques to evaluate it. However, with that comes a lot of error, and with that error, a lot of inconsistencies, and it gets back to the experts of how to, you make a 1% error when it's a milligram per liter. It's not real big. You probably can't even do. You make a 1% error when it's nanogram per liter. It's big. It can be really big in the way the toxicity goes. So as I said, the analytical, we're getting lower and lower and lower. It's getting more and more costly. So with that comes the advancement of screening tools. Screening tools are great. They make things much more affordable to do in quantity and getting better in quality. But in some instances, you have to evaluate whether the screening tool is really evaluating what you think it's evaluating, because many times it doesn't. We also have, traditionally for a lot of organic chemistries, we would do targeted analysis where you had to name the chemical and then go look for it. That works really well, and that's where a lot of precision is. But you have to know what you're looking for. And if you're trying to look at what, there's harm out there, but you don't know what potentially is causing your harm, you now have non-targeted analysis. And that's just basically a large screening tool, and you're counting sub-atoms, and you're counting protons, neutrons, and electrons, and then having AI generate what that compound may be. So it's a mean likelihood assessment. They work really well in some instances, but they're often misapplied. We also have isotope forensics, where you can actually go in, and works really well for a lot of naturally occurring elements. And then the real big game changer is passive sampling, where you have the ability to put something out into the environment and assess what is out there. While I don't think it's necessarily applicable now for natural resource damage assessments, you also have the techniques of eDNA, where you actually can go in and not sample the organism, but if the organism, for example, is a fish, swam by, you can actually figure out by just the molecules that it sloughed off of if it was there. And that works really well for secretive or rare organisms. So, it may have some opportunity for creating an opportunity for, better surveying techniques, and where it be more comprehensive. And then I think the other thing that's most important as it goes to the technical and the experts is really peer-reviewed literature. Peer-reviewed literature used to be the gold standard. However, there's been such a rush to get things out on the market, for journals to get eyes on the, they're not making any money per se until they get eyes on the content. So there's a lot of sensationalism going on. Reviewers aren't doing what they used to. Many reviewers are doing, I think subpar. I mean, that's bad for my profession. Rick and I have talked about that a lot through CTAC, through his responsibilities when he was editor-in-chief in the journal. But it just really is challenging. Look, a couple things I would like to leave with you is many people just read the abstract. The abstract is like reading the headline. It's saying, look at me, I have this article. When you read the abstract and then go back and read the article, but many times for many journals, not Rick's journal when he was that, but when you read that, you see that it doesn't, that they didn't study what they're saying, they studied in the abstract. It's important to read the results. The discussion is the what if, where they say, this may mean something, and it has nothing to do, it's the speculative side of things. And often the abstract and the discussions is what gets picked up on, but it's really the thing that's most further from the actual science itself. That's all I have for right now.
Okay, thank you, Bill. Our next speaker, Tim, is on virtually, so we'll hopefully pull him up in a moment.
Tim, you're muted.
Thank you. All right. Well, hopefully everyone can hear me now. Apology I can't be there in person today. I've always enjoyed the networking at these meetings, but I'm calling in from Denver today. So I was asked to talk about some of the technical and scientific developments from my view, from the perspective of the Department of Interior. So I have 4 areas I was aiming to touch on: updates to NEPA, improved restoration with native plant materials that we've been working with, a new tool for assessment study planning, and our efforts to support knowledge transfer among Interior staff. And I know, Lauren, you were asking about some of the Type A updates, and I'm going to kick that down to later in the day when the director of our office, Emily Joseph, will be speaking, and she'll have some comments on that. So first off is the National Environmental Policy Act. We're actively watching how NEPA updates can create opportunities to expedite on-the-ground restoration. At Interior, we've often advocated for streamlined approaches to assess restoration projects through that NEPA lens, especially those that are just clearly beneficial and have minimal short-term impacts. And we're excited about the potential to be able to use categorical exclusions from across different agencies to help us move faster and get that restoration on the ground. So that's something that we're actively trying to figure out how we can get that done and get some of these settlement funds spent down. And onto restoration implementation, we're also closely working with the National Interagency Seed and Restoration Center at the department to ensure that native seed and plant materials are available to nurture our restoration projects. For over 2 decades, for those that aren't familiar, Interior has promoted the idea of right seed in the right place at the right time through the Seeds of Success program. By selecting plant species that are best adapted to a site's local conditions, we can reduce the time to restoration, improve the use of ecosystems by wildlife and recreational uses, and increase the likelihood of long-term restoration success from these NERDAR cases. We've all known about a lot of these benefits for a long time. However, it's often not used because collecting and growing these plants takes more time than just using more readily accessible plant materials. But folks from the Seeds of Success program across Interior are developing a locally sourced seed supply chain. And this is mainly from the need for post-wildfire and natural disaster recovery, but we're trying to see how we can support this and improve NERDAR restoration project success. Switching gears a bit, on the science planning front, we have been working with our partners at the U.S. Geological Survey, and they developed a really great new tool. It's called the Study Prioritizing and Organizing Tool, or SPOT. So as many of you know, NERDAR cases, and Bill, you just kind of touched on this, is that they rely on a wide variety of studies to assess resource injury. And it can be a challenge to make an agreement on what is the path for which studies to implement for how long, what are the off paths for that. And this SPOT tool can help trustee councils create smarter, more strategic use of studies in their assessment plans. It attempts to bridge the technical silos and capture the thoughts of the various disciplines involved in NERDAR and give room for new information to reshape the direction of where studies go. So this was just developed about a year ago, and it's been beta tested in 4 cases over this past year. And it does take more time up front, but we're excited to see how it brings teams together with a shared vision on how to move this forward. And the impetus for the development of SPOT was that we were starting to see an upcoming challenge, which is my next point, which is staff turnover at the department. We've experienced a wave of retirements over the past 5 years. Many seasoned case managers have moved on. And while we've tried to plan for smooth transitions, hiring ahead of retirements has not always been possible. So in response, we created that SPOT tool to help have more ability to look through that. And then we've also created a NERDAR mentorship program. We just finished our pilot year of that program, and we have paired experienced case managers across Interior with 1 to 2 mentees each. The entire mentorship group met monthly and had frequent one-on-one check-ins as well. And that all culminated at the end of last year in a 3-day in-person workshop. The program was a great success. Participants reported significant knowledge growth, and we're really looking forward to formalizing that program. And then beyond mentorship, we're also focused on building capacity through training NERDAR practitioners across federal, state, and tribal groups. We've been hosting a NERDAR overview group for our co-trustees and a NERDAR 101 courses, bringing those across the country. And then supporting the NERDAR community with investments in scientific research and technology tools, and creating interdisciplinary connections at places like this, CTAC, Society for Ecological Restoration, where we're able to share the ideas like we are today. That's all I had. Thank you for the opportunity to share.
Okay, thank you, Ted. That was great. Save us a little time too, which we need. So we've talked about legal issues. We've spoken about technical issues. Now we're going to get into economic issues, and we'll start off with Al.
Thanks. Thanks very much. So welcome everyone, and special thanks for Barbara for inviting me to be involved in this. I think it's really fascinating, interesting, and important. So I'm seeing Bill DeVoge in the audience, and it sort of reminded me how I first got exposed to NRDA work. It was the Exxon Valdez. There's a big meeting in DOE's like auditorium where Team Exxon with all the MIT and Bill and others came in with a bevy of research, mainly centered on the criticism of state of preference, but not exclusively. There was also economic theory and other things about how we judge or should measure benefits theoretically. And then there was sort of a different team paid mainly by Department of Justice, I think, on how they would evaluate, again, using stated preference methods like contingent valuation, but others as well. And I was a young, like GS-12, brand new economist at the time, and I'm like starstruck and also equally shocked that our profession, our science could be in such disarray. So I will say that that was a long time ago, and I'm very proud of the profession for environmental economics was a kind of latent or, incubation field at the time. There were very few departments that even had an environmental economics field to specialize in. And now every university in the country largely that offers a graduate degree, offers work in environmental economics, and it attracts, instead of being a small field, it's one of the largest fields in economics now, and it attracts some of the very best and brightest economists in the world. And so from that process, it's not surprising that we would make a lot of progress in thinking these issues through. That said, I'm going to talk mainly about the sort of issues that are on the horizon. I'm not going to talk a lot about state of preference, although I was fascinated to learn that there might be some legal issues with the status of it. So I'm definitely something more I'm going to watch and talk to my lawyer friends at EPA and elsewhere about that, because that's very important, because we do use it in other aspects of environmental economics. I'll note before I get started, though, that President Trump issued many executive orders, but one was called the Gold Standard Science Executive Order. And the executive order lists 9 tenets of what is gold standard science. And I think some of them, or maybe all, but certainly some of them are really relevant for us today. And they include transparency, and we talked in the previous panel a little bit about the growing transparency of natural resource damage assessment, but consistency across assessments and consistency with the principles of the science of economics, in my case, or the principles of other kinds of science. The cost effectiveness of the science and the timeliness of the science as well, and the reproducibility of the science, and then finally, the communication of errors and uncertainty. And so in my remarks to follow, I'm going to sort of raise things where these things have to be resolved, it seems to me, both in the NRDA work, but also, like I often have worked in the past with the Justice Department on enforcement cases, and some of that might involve, for example, what was the environmental or human health wrong of the cheating or of the environmental rules. So there's lots of parallels, I think, in other work that EPA does as well. So the first big issue is discounting. So even in the simple discounting framework, I think we all intuitively know that this matters a lot, right? I used to tell my kids about the 7 wonders of the world. Now I say that discounting or compound interest is the 8th wonder of the world. So for example, if you take a damage or a benefit 20 years in the future and you discount it at 2%, you take 33% of that value off the table when you discount it back to present value. If you use 7%, you take 75% of the value off the table. And of course, if you go out in longer time horizons, it even gets more profound. So at 60 years, 2% discounting would remove 70% of the value. And at 60 years, 7% discount rate would remove 98% of the value in present value terms. And why does that matter? I picked 2 and 7 for very specific reasons. The Biden OMB guidance on how to do benefit cost analysis and assess benefits or damages prescribed a 2% discount rate. President Trump, again, through an executive order, went back to the guidance that was first issued by OMB in 2003, and that prescribes a 3% and 7% discount rate. So that choice largely needs to be informed by economics, and economists and economic science will matter a lot, I think, going forward. And it matters for NRDA as well, because a lot of the damages or foregone economic ecosystem service flows are in the future. So discounting is number one. Second thing to note, I was a little surprised to talk about the dominance of climate change in this audience. I thought that would be less of a concern, but maybe that reflects my early exposures to Deepwater Horizon and Exxon Valdez, where climate change largely did not come up that much. But the social cost of carbon, which was a monetary value of damages employed by the Biden administration and the Obama administration, was discontinued by this administration through an OMB directive. Third, a new development is the use of machine learning and artificial intelligence. I think some of you might know that in waters of the US, a team mainly out of Berkeley has used artificial intelligence to predict what waters of the US would be covered by the Clean Water Act and which ones would not, and based on different rules, and that published in Science and other places, but that I think opens a big opportunity for applications in this world as well. A next new development, which I think is largely not popularized yet, is the use of integrated assessment models to assess damages. So we call them IAMs. They've been first used in the climate change arena, but they're often now deployed. There's several of them that exist now in the water pollution and wetlands damages area. And so what that allows you to do is you can take an off-the-shelf, very complicated, but off-the-shelf model and deploy them again and again and again in a consistent and a cost-effective and a timely way. So you don't have to recreate the wheel every time you have an NRDA or a pollution issue to think about. It also allows economists to gather around these models to critique them more transparently and then to hopefully arrive at a greater consensus on what are the appropriate parameters in those models. Next, and another big area is sort of what in benefits assessment is called equity weighting or other. So there's a traditional welfare analysis where $1 to any citizen is counted as $1 to every other citizen, right? But of course, that ignores an income effect. And so again, in the Biden OMB Circular A4 and the Biden A4, there was instructions on how to do equity weighting. So you could weight $1 of benefits to someone with lower income more than $1 of benefits to someone more, but again, with the reversion back to the previous A4, that is no longer on the table. And then I'll close because I'm definitely running out of time, is that I want to get into the points about baseline conditions, data availability, and finally benefits transfer, which I think is a big issue as well. So baseline conditions and data, I think are on the horizon. So we did a study a while ago where we used cell phone data to do a travel cost model to figure out how many people were traveling to certain water recreation places before and after certain economic changes. They weren't an NRDA application, but I think that and other applications with satellite data, et cetera, open up a wide array of data possibilities that we've only begun to scratch the surface for. And last is the benefits transfer thing. I think that's like the new Exxon Valdez stated preference controversy. It's extremely difficult to apply a benefit study or a damage study that was done at time A in place B and apply it in time X in place Z. So so we've done work, say, in the Chesapeake Bay, and those very iconic resources like the Chesapeake Bay tend to be valued much higher, no matter what kind of methodology you're using, versus some like elsewhere, smaller or less iconic. And then finally, the issue of substitutes matters a lot. And so whether we're dealing with a Deepwater Horizon with the swath of geographic 5-state coverage, that really wipes out a lot of substitutes. If you're just dealing with one small area and where substitutes go, there might be plenty of other substitutes for recreation or ecological service values. And so all that has to be counted in. And I think we're only on the cusp of thinking those things through systematically and well. Thanks.
All right. Well, thank you, Al. Let's turn now to Ted.
Yeah, thank you to everybody for coming. Thank you to Barbara for inviting me. Thank you for Al for saying a bunch of stuff that now I don't have to say. I want to start out by talking a little bit. I'm going to talk about NERDA, but I think many of the things that we're addressing also pertain in a broader landscape. So for example, anytime you have an investment, not just an accident, but an investment, you have side consequences. And Roger Martello was talking about kind of expanding that sense of investment to make sure that you have no net loss or even a net gain. So what does that mean? That means some sort of compensation for the negative effects. And that is what NERDA is doing. And I think the primary issue that arises from an economic perspective is that these effects are multidimensional. Things are going in different directions. Some services are up, some services are down. The mix changes. What you injure and what you restore are not exactly alike. They're in different places, et cetera. And as a result, you have, no matter what you do, some people will be undercompensated and some people will be overcompensated. And how do you decide whether you have done enough and the public is compensated? That's a fundamentally difficult problem, and we solve it really poorly. And I think that that's a kind of where we are and my note for the future. So going back a little bit in time, I appreciate Al's bringing up Exxon Valdez and the contingent valuation wars. Pre-1994, that was the approach. It was heavily litigation oriented. The whole idea was to take these injuries and translate them into dollars using some sort of valuation methodology, which were incredibly controversial, and also brought a great deal of careful attention to methods and how they work, and are they legitimate, and are they reproducible, are they defensible, to a reasonable degree of scientific certainty, which is the standard. That was a difficult time. Then in 1994, there was really kind of a sea change, and I'm going to talk primarily about ecological effects and not recreation and those kinds of things, where it was really realized that this whole idea of taking your injury and translating it into dollars was both incorrect, biased, but also difficult to do and unnecessary. So there was, this notion of habitat and resource equivalency kinds of analyses where you had both an injury side and a restoration side, right? You didn't just translate injury into dollars, you translated injury into dollars and restoration to dollars. And so you measure both sides of the equation, right? It was also recognized that you could, in some circumstance, get rid of the dollars. And that valuation part that was so hard suddenly became very easy, as under extremely narrow set of circumstances. You could say that the public is compensated in the same way they would be if you measured the dollars using resource and habitat equivalency and not going through dollars, but those circumstances are extremely limited, right? So that's where we were. Tony Penn and I wrote a paper about doing that kind of thing for the Lake Beret oil spill. And I think a big part of that message of that paper was, look, we can get together and use this very simple technique to kind of make progress and get cases settled in a pragmatic kind of way. For the next 25 years, that was the vast majority of practice. Very pragmatic, settling cases, and doing it using methods that were useful, but not defensible. I have a little heartburn with giving those methods rebuttable presumption, but I understand the sentiment. We arrive at this very difficult spot where we are now applying these methods that are settlement methods in very big cases that are very complicated and don't fit the paradigm of those methods. And the techniques have been essentially stagnant. I mean, Bill talked about, Goodfellow talked about advances in science, and there were advances in science, but those are inputs to an economic model that really didn't advance at all and is very rudimentary. So where are we kind of now? Lauren Daniel and Brian Israel, Brett Marston have a wonderful book on NERDA. And at the beginning of it, they talk about the distinction in the phases of a contaminated site in which there are toxic torts and there are NERDAs. And those are distinct from one another, right? And they're distinct on the basis, in part, that toxic tort is really about individuals and these private claims. And the NERDA part is about resources and services, and it's the public. And that was somehow a distinction, maybe less cogent for compensatory restoration. But now what we are facing, and a huge part of my practice, is actual toxic tort cases, actual tort cases and tort causes of action. And you read through all this stuff and you get to the prayer of relief, and there's something that says natural resource damages. And so there's full overlap between these two, and sorting out how you are going to bring natural resource damages back into court, back into a mapping from injuries into money. We're kind of back where we began many, many years ago, with very little advancement in the meantime in the methods. And I think that's a huge issue for Daubert kinds of challenges to not necessarily the science inputs to these things, but what are you doing? What are you actually doing? And the good answer is not, well, I've been doing it for the last 20 years and it's just what we do. So what I would like to do is say, we're kind of back in that circumstance that we were in a long time ago. And what we need is some progress. And I would hold out that some of the things that Al was talking about with advances in economics that are addressing complicated problems have been made, but we haven't brought them to NERDA, and we should. These are sort of modern welfare economics that deals with multidimensional setting. Lots of things going on that are changes. People who disagree about what those, the valuations of those different changes. We're not all unidimensional. And how do we aggregate up those preferences, decide when the public is compensated, when we're only giving them one thing, and some people think it's not enough, and some people think it's too, are overcompensated. How do we build in this sort of aggregation of preferences? How do we do it in a way that satisfies efficiency criteria? How do we can also build in equitable criteria where restoration provided to a community that is very has a paucity of resources, is more valuable than the same restoration to a community that's flush with resources. How do you bring those all together in a modern way in order to bring to courts a justifiable set of methods when married with good science, puts on a case to a reasonable degree of scientific certainty, which is a daunting bar. So there you go.
Okay. All righty. Thank you very much, Ted. That was so nice and clear. Thank you. Really good. So our last topic, turning now to policy. Ruth is going to cover all of it by herself.
All of it. And actually, bring it all together, batting cleanup the chamber. I first actually request I be off the record, not because I have anything controversial to say, but I have a problem of running my mouth all the time. So I'm trying in the spirit of risk mitigation. I would like that.
We did have a change in reporter. Not only did they go from that corner to that corner, but we now have Emma, who is representing inside EPA. And we had said this morning, I'm sure your colleague told you, that if anyone wanted any part of what they were saying to be off the record, they just needed to say that. Okay? So.
Off the record. Thank you. Thank you, Barbara. It's been really great. Thank you so much for having me this morning. It's really a privilege to talk to this group. I think conversations like this that surround our natural resources and natural resource policy really necessarily need to be approached from a interdisciplinary, intersectional way with, bringing science and industry and government and law in the room. And I've seen a wonderful execution of that today. So thank you so much. I don't think I'm going to say anything today that you didn't already hear from either Roger Martella or Roger Nober this morning about the state of natural resource policy in the United States. The state of natural resource policy is anything but business as usual right now. We are 6 months into Trump 2.0, and we are navigating a drastically shifting landscape when it comes to these policies. Since his return to office, the administration has moved swiftly to reshape the federal government's approach to environmental regulations, enforcement, and natural resource stewardship. You're seeing this already reverberate through all levels of, natural resource policy. And we know they're already influencing how corporations assess risk, manage compliance, and engage with shareholders and regulators alike. So some top line policy context. The Trump administration's second term has been marked by a renewed commitment to deregulation. I know there was some conversation this morning about whether it was deregulation or it was a refocus. I don't necessarily disagree that it's a refocus, but I think nobody at the White House would have any qualms telling you what they're doing is trying to deregulate. Since the goal, they're not trying to hide anything they're really doing there. Within weeks of taking office, the administration had issued a series of executive orders aimed at rolling back environmental protections, pausing enforcement actions, and revisiting key regulatory frameworks. And we're seeing this broadly across all government agencies. He's really yielding that power. The DOJ has paused enforcement cases, the EPA and Interior. We're happy to hear them today, all that work they're doing. But they've been directed to streamline permitting and reduce regulatory burdens, particularly on energy and infrastructure projects, and we're seeing that happen. And then most notably in terms of changing frameworks, NEPA was brought up earlier, but NEPA has been significantly weakened with new rules that establish different guardrails and scope restrictions. And I think lucky for the Trump administration that right now they have Congress and the courts, or the Supreme Court at least, on their side in all this policy that they're pushing, specifically with, NEPA, the 7-county case where it was decided where that was kind of, we're just curtailing NEPA. It was an 8-0 decision. And, I heard someone say yesterday that they thought that case was more important to permitting in the US than any permitting bill would have been. So I thought that was a really interesting take, and whether or not it's correct, I think it's just fair to use it as an example, as, the administration really has the proverbial wind at its back when it's approaching these issues. And I think the fear is that these moves signal a clear shift away from the precautionary and restorative principles that have historically undermined environmental regulation and enforcement. And I think we're just going to have to kind of live in a place where that's happening. So I do think when we talked about whether it was deregulation versus, sorry, my mouth was refocusing, the administration's agenda, environmental agenda, powering the Great American Comeback and the National Energy Dominance Initiatives, emphasize energy dominance and economic growth at speeds previously unseen. And what does this mean in reality? It means that they want gas. They want domestically produced gas. They want lithium. They want rare earths, and they want them domestically produced, and they want them fast. Permitting that would take 1 to 2 years at the least. I think it takes 30 years to permit a mine in the US, previously. It's taking 2 weeks, 4 weeks. So we're just on a really kind of crazy time schedule. Professor Nober mentioned this morning, but I think in the absence of a permitting bill from Congress, Trump is really doing everything in his executive power and then some, possibly, thank you so much, to using all that executive action he can to move as forward as possible. And whether or not that holds up in the future, it doesn't seem that they care, but it seems like they're, just moving fast, breaking things when it comes to resource development in the US. And I don't think their goals are necessarily at odds with environmental protection, but they do indicate this real pivot in federal priorities. A lot of those, top line priorities being stuff that we've already heard here today, public-private partnerships. Last week, someone mentioned it, but last week or 2 weeks ago, the Department of Defense became the largest stakeholder in MP materials, which is a rare earths mine. And I think that was an extraordinary move by the government to do something like that. Under, the auspices of this, Cold War era rule, the Defense Production Act. But it's just kind of indicative of him or the Trump administration using all their, the maximum executive power to try to get these things moving while they can. And they're also focused, it was said this morning, on carrots and not sticks, on getting people to do stuff not by, punishment or regulation, but by kind of, entering these partnerships. And of course, deregulation, as I've talked about. So I think for the purposes of the conversation at hand, the results here could be a mixed bag, right, of what happens next. Projects are moving fast, but what does that mean, at the end of the tunnel? There obviously may be pressure to downplay or defer damage claims that could impede this development, this really quick development and infrastructure development. But it may not even matter because, we may see restoration projects deprioritized in favor of resource extraction. I think, they definitely have a different goal in mind. And we also have to consider that federal funding is being cut, everywhere. And how is that going to impact any of the work that, people do in this area? And that includes the reduction in force measures, like the reduction in force and the retirements that DOI talked about. All these are going to have an impact on what they can get done in the next 3 years. And this policy is leading to uncertainty in both public, in stakeholders engaged in natural resources policy. For corporate actors, I think these changes present both opportunities and risks. On one hand, reduced enforcement means litigation slowdowns, sorry for the lawyers, but and that may offer short-term relief, but companies may find more flexibility in negotiating settlements, delaying compliance obligations. On the other hand, regulatory uncertainty complicates long-term planning, as many people here have said this morning. None of this is really good for long-term planning. They are trying to incentivize long-term investments, and is backfiring a little bit because these are all kind of uncertain and not done through Congress. So they're all kind of on shaky grounds with where they go in the next, 4 years, 2 years. And moreover, the reputational risk remains high. That social license to operate is always going to be necessary. You're always going to need that. And I think companies have a massive incentive, as they do, this day and age, to maintain their reputations, regardless of who is in office, by kind of doing the right things. So where does this leave us? Everyone working in the space, working in natural resources, is learning to kind of adapt to a fragmented and politically charged landscape. I mean, it's kind of always been like this in energy policy, natural resources policy, but it kind of feels kind of amped up in a way now. But this is going to require the private sector to actually step up. I think it's been discussed what the private sector could do this morning, but investing in voluntary restoration and responsibility initiatives that go beyond compliance and build goodwill are going to be necessary in this new environment, as is leveraging data and technology to improve damage assessment methodologies and demonstrate environmental performance. We talked, the DOI, Tim discussed the USGS project that, is mapping different things. And I think we're going to need to see a lot of that kind of from that research from the private sector, given the circumstances moving forward. In short, policies that regulate our resources are evolving, and we need to look at them kind of within the context of the administration's priorities, which is, resource development, domestic resource development, and fast. And those, I think, who anticipate these changes will be best positioned to navigate that road. Companies in the private sector, and I wrote this down for this morning, Roger Martell said, can be a force for good. And I think that's right now where that opportunity is. I think the smartest thing for any industry or project right now in this environment is to have good corporate governance. A lot of companies have relied heavily on a regulatory system that's kind of now taking the handcuffs off, but it's not going to alleviate them of their responsibility for good stewardship in order to maintain their social license to operate. And additionally, they need to consider that Trump isn't going to always be the president. Not that, but Trump isn't always going to be the president. But that, this is why I went off the record. So isn't going to be the president, and these things could change in 10 years. We might be looking at a totally different landscape. So approaching this, they're just going to have to say, okay, what's the best we can do, knowing that things are going to change either way in the future. So really exciting, but also uncertain time to work in the natural resources policy world, but happy to do it. Thank you.
All righty, so we're going to turn to a little inter-panel discussion. And if it's okay, Barbara, I think since we have 7 panelists, instead of calling on all the panelists like we did on the first panel, I'll pose a question. I'll pose a few questions and then ask for volunteers from the panel. Audience. Okay. Okay.
And Tim, if you'd like to come back on screen, we can have you in the room.
And if I don't get any volunteers from the panel, then I'll call on somebody. Okay. All right. So the first question, we've talked about 4 topics. We've spoken about legal, technical, economic, and policy. And so in the context of NRD, what do you think is the greatest alignment, or perhaps more importantly, the greatest disconnect among those 4 topics? Who would like to take a cut at that? Disconnects between legal, technical, economic, and policy. I think I see.
Yeah,
Lauren.
I'll take it. So I do think that there is a disconnect between the techniques that are used to assess damage and assign value to damage, and the legal standards that are implemented by courts and litigation. And I think a huge reason for that is that there are so few NRD trials. And I think one of the reasons in turn why there are so few NRD trials is that there is a disconnect between the methodologies and the legal standards that are applied to those methodologies in court. So I'm not sure that that's a disconnect that can be or will be solved. And I think that the sort of natural resolution of it is that we will continue to have an environment where the litigated NRD case is very, very rare. Nevertheless, I think that we all sort of need to stay attuned to those issues, particularly in the technical fields, because the day will come when we do have a case that requires litigation because of the size, the scope, and, the incentives of the parties that are at the table.
I just want to follow up real quickly, and it's to my mind, it's not really just about whether things are go to trial where this disconnect happens. It's also not good policy to have a systematically biased set of methods repeatedly applied to even smallish cases in settlement. You get it done and you save on transaction costs, but there is a cost of being wrong, frequently. So I think there's a balance there. It's not just about litigation. It's also about, are we doing a good job in the repeated application of it to small or medium-sized cases?
As someone who brings small or medium-sized cases, I want to speak in favor of HIA and RIA. It makes intrinsic sense to me that we measure how many ducks landed in the stormwater retention pond that had hydrocarbons in it and died, 30 or 40 or whatever it was in this last case. And then how much money it takes to restore enough habitat to have roughly 30 or 40 more ducks. That's not crazy. It may be difficult biology. Exactly how many hectares does it take to restore ducks? But I can't speak to the bigger cases, but for smaller cases, I understand the economics are a little gray sometimes, but the macro scale understanding of both HIA and RIA, I think is something that's logical to judges and is risky for defendants to go to trial on. And that's why we don't see many trials. I think we don't see many trials because they are at least facially attractive concepts that would be difficult to overcome. The plaintiffs could put on a good case and it would be difficult for defendants to overcome them. Lauren may rebut.
No, I'm not going to rebut. I think that that's right. I think that there's difficulty on both sides. And I think that, right, you know, it's sort of a self-perpetuating thing that the lack of case law, the lack of precedents, makes it riskier for both sides to litigate these issues to completion. And I think that applies actually to summary judgment as well. Right. So I think it's very risky today for a trustee, for example, to subject a contingent valuation survey to a Daubert motion. Right. And so you are probably not going to see that happen. You're more likely to see it used as a tool in negotiated settlement. But while both sides know full well that probably the trustees would make the judgment that they're not going to push that specific technique all the way to the point of getting tested by a court.
That specific technique, that's probably right.
It's just an example.
Let's see, I think I saw Al's light.
Yeah,
come
can
on
I
first.
just opine quickly on the example of the ducks? If it was your dog that was killed and they bought you a puppy, are you just as well off?
For the practical administration of government and making society whole, you have to make approximations in order to be efficient.
Yes, but I think Ted's point was you're systematically biasing it in one direction.
Let me also just
Bill?
clarify
Go ahead.
slightly, a little bit of a false dichotomy here. I mean, your example of the ducks is exactly when this does work. All of the services of ducks kind of go with the number of ducks. There's more to see, there's more that die and get eaten by other stuff. And so in that exact circumstance is when preferences do align. Everybody agrees that more ducks are better than fewer ducks. And this simple method works perfectly. That's not every case. And moreover, my remarks are not that you do that or you go to contingent valuation. My remarks are, these are difficult problems and we can do better.
Bill, did you have a comment? I thought I saw your thing. Okay, well, back when I was at Interior, we developed the type A and type B rules initially. This same issue between efficiency and correctness or equity was there. So this is not new. I guess I'm kind of relieved to hear that something stays the same. Any other commentary on this question about the interaction among the four topics? Okay, turning to another question. Yes. Please, go ahead. So we can do audience and panel together, right?
Sorry, just a follow-up. I was hoping Ted was going to chime in and answer with that one too, because I was on a great session with Ted about a year and a half ago where I learned a lot as a lawyer from a lot of the economists and scientists. I want to follow up with that exact issue is what are some examples of new approaches that we could use that add scientific certainty, and what is the cost? Because I feel like the cost has been the elephant in the room throughout a lot of the discussions earlier. I wrote down some quotes from some other speakers about the added spice. There we go. And it's the cost. I mean, in my view, I am a regulator. I'm a lawyer for NOAA, and cost is a very significant issue for us. It's always in our mind is what is this going to cost? Because that's always a part of our thought process for settlement or getting to restoration. We have these grandiose ideas of what restoration is and could and should be, but we can't afford it most of the time. The cost is the issue. So my follow-up is, do you have, what ideas do you have that you could share with us about new approaches for scientific certainty, and what are the costs related to that? If you have.
Is that addressed to you, Ted? It sounded like.
I'm looking at Ted because I think he has ideas. I'm sure he does, right? But other people as well, for sure.
Okay. Bill.
I'll let Ted answer that.
Yeah, I think, I certainly understand the cost element. I think there was a lot of good commentary earlier about the costs associated with collecting data and doing these studies. And I think that, essentially the problem is we have inherent uncertainties and you have to fill gaps, but it costs to fill gaps. So you need a benefit cost analysis of your studies. That's something that can be done within a decision analytic framework. And you can kind of say, well, here's what we would gain from a study, and be very mindful of the cost elements. But some of these things are not costly. The discount rate is not costly to fix. Al, I appreciate your raising the discount rate, but you didn't raise what is maybe the hardest problem, is that not only are we discounting the future to small numbers, we are expanding the past to large numbers. We're essentially putting an ethical weight on people according to when they are born. That's something we should fix, and that's something we can fix. And that's just a matter, there's almost no cost. You just do it right. Other things are costly. The essential tension is between the existence of methods which can use quantities. We don't have to go to dollars. We can use quantity metrics in order to do a fulsome and defensible analysis, but it does require more information than we typically use. So it's a matter, again, of matching the complexity to the case. But the idea, I won't say it again, but I won't say it again.
So just one reaction to this conversation, I think, is that I think we're identifying probably the most extreme tension that exists between law and the tools. And that is that, right, in order to make a legally defensible scientific assessment, you have to gap fill in a way that's not cost effective. And so I think that, right, David sort of poo-pooed the rebuttable presumption a little bit, but I actually do think that that is where the rebuttable presumption is supposed to help, right, is if you can find the right balance between cost and benefit associated with gap filling where we don't have complete information, then, right, there should be some legal benefit to that, because we are sort of achieving a goal that everyone can get behind. I think that what we've really struggled with, which is clear based on the status of the current regulations, is striking the right balance there. And I think that one of the things that has to be taken into account in striking that right balance is cooperation. The other way you solve the cost problem, right, is a cooperative assessment. And I think that if we can get to a place where PRPs are also, influencing the way in which these gaps are getting filled, we are going to get closer to finding the right balance between gap filling and spending costs to fill gaps more quickly. Now, of course, that doesn't necessarily take into account the parties that aren't at the table, right? The public that may have different views than their government representatives do as to how things should be restored, or what the damage associated with an event looks like. But I think it comes closer. And so I think like cooperation is just sort of a mandatory, and I know we all know this, but a mandatory element of sort of the policy implementation forward.
Yeah, and I agree with that. I don't want to poo-poo the presumption too much, and it can gap fill, but just for scale, some of our claims are $200,000, okay? It's not good government to spend a lot of money assessing and ending up with $200,000, roughly of injuries. So that's why we turn to the tried and true HIA and RIA.
This is why we had lookup tables in Florida way back when, or at least the impetus for it, to be honest with you. I know Bill has a comment, but I wanted to just solicit if anyone online has a question, that they should put it in the chat box. We've got about another 15 minutes to go until we take a break. Jay has a question. And Bill, you have a question?
I have a comment and a. question.
Comments? No comments, questions.
Well, a comment leads to a question.
It's a comment leading to a question?
Of course. Yeah.
Okay,
And I'll only use 12 minutes, Barbara. You
all
know
right,
that.
go ahead. Go ahead, go ahead.
Well, I guess, Lauren, Mike, I've got a comment and a question for you. And I guess my comment is that I appreciate you burying contingent valuation. However, there are cases that are going on right now where there are certain trustees that have conducted contingent valuation studies. They call them different things, but that's what they are. And they're using those to try to bring very large claims against companies. And that's not gone away. There's also some groundwater cases now in New Jersey because they weren't happy with the numbers they were getting just with using certain methods. So now they're doing CV and the certain methods. So we'll see whether or not CV's gone. But clearly, if we have to follow some of the things that Al outlined, which I thought were terrific in terms of what kinds of criteria do you look at, that's really good. Because I think the methods need to meet those kinds of criteria. And I'm welcoming to see what we get out of like improvements in benefits transfer. Because I know the agency for years has relied upon benefits transfer because they don't have the resources really to not do anything other than benefits transfer. And that's really important because it also underlies a lot of NRDAs as benefits transfer. So any further improvement on benefits transfer would be more than welcome. And I'm also thrilled if you could share more of your experience with using mobility data. Because I think that really is an opportunity to cut costs quite substantially in doing damage assessments, is being able to collect that kind of data. And so what kind of guidelines do we need for using that kind of data? And what your experience has been with using that? Because that does matter. Because, I mean, economists do go to court. Okay, we have gone to court.
So on the burying contingent valuation point, so I recognize I was being a little bit glib, and of course, right, it's still being used and discussed, and I think really is, in my mind, should be viewed as a settlement tool, because I really think that there are serious problems with admissibility of most, it depends, right, on the design of the survey, et cetera, et cetera. But I did just want to give a plug for the Dan McFadden, Kenneth Train edited book on contingent valuation, which I think, Bill, you might even be an author in that book too. I can't remember. But I just want to say that I do think that, right, that book does give like a pretty thorough overview of all of the issues associated with these surveys and includes a chapter that Jean Martin co-authored related to the legal vulnerabilities associated with it. So I would just encourage all of our trustee friends, to read that book because I think it is very problematic.
So I think that this panel is a very good segue to the next panel, which is really quite pragmatic, that is going to look at, how do we align like objectives to get to where we want. But there's really two strategies here. One is there's a methodological strategy that is running through all of this. And then there's the case-specific strategy that will be more discussed, I think, by the next panel. But some of the ideas that have been, mentioned here, I think that we should follow up on some of this. And we should be able to identify what are the methodological needs that have been discussed. and the inadequacy of them. Contingent valuation is, I have to laugh in a way because, to be honest with you, there's been no change. People who think it's a useful technique view it's a least useful technique. People who don't. In Europe, they use it a little bit differently. But it's a little bit like when we've had so many conversations and we've had so many visitors over the 37 years of this group, including that we've met with the Council of Economic Advisors and basically had a conversation with, I'm losing who the person was. I think he went to Princeton afterward. You can help me on this. We've had conversations with Nobel laureates, but particularly the Council of Economic Advisors, viewing that contingent valuation, and this is in published books of the Council of Economic Advisors under various presidents, that it's used as a gauging, if you will, technique, not to exact liability. So when you say a settlement tool, but I would not want to encourage anyone to use it as a settlement tool. Whereas I do agree on he or rhea can be used in that context. I'm sorry to usurp you here, but you've got 10 more minutes if you want.
I think
and Jay had a question.
I was going to turn to Jay, yeah.
Want that question? Yeah. So I think, though, that we're on a couple of different levels here, which is terrific. I think having this kind of conversation is exactly what we want. It's the state of the practice, and the state of the practice in some ways is not adequate for the current needs. So it's very interesting.
I'm used to you taking, Barbara, I'm used to you taking over, no problem.
So I want to pose a question that maybe is looking for some advice. Carol Jones, who some of you know, and I are working through the Environmental Law Institute with an international group who are working with different countries in applying this to wildlife, damage to wildlife, either from poaching or other illegal activities. So that's one starting point, is that it's always was something that has been illegal. But one of the issues that we've had is that most of the government people that we talk to, and even some others, really only want either the lookup table or market valuations. And even though okay, HEA is not perfect, it makes more sense, but we are having trouble getting away from a market value when you're talking about limited numbers or something. And David, you mentioned 200,000. We're talking 20,000 or 25,000 for extremely rare cacti taken from the Atacama Desert to Europe. And what are you going to do with $25,000? So, ideas.
Comments from the panel on Jay's question? Yeah. Let's see, Al, do you have a response to that, or your view?
No, I think that points to why I'm sort of skeptical of that as an approach. I mean, I definitely do not think that stated preference or contingent valuation, which is a subset of that tool, is perfect. But I mean, the McFadden book is 35 years old. And as I mentioned in my opening remarks, we've made the profession, not me, have made a lot of progress resolving many of those issues. So even some of the skeptics are willing to say it's useful. I think a lot of times people attribute this to Keynes, but I don't think that's accurate. But he said I'd rather be vaguely right than precisely wrong. And I think that's where we are right now. If you use a number out of a book that's ad hoc at best.
Just to clarify, there is, I think it's 2017 McFadden Kenneth Train book that it's a compilation of various critiques by different authors that they edited. So that's what I was referring to.
Let me just quickly add that I think Rick and I kind of ran into the same thing when looking at the Ukrainian methods, that they were really drawn from, you know, ducks died and there's a fine for killing a duck out of season and let's apply that. And they're sort of rudimentary ideas. But it goes, I think, to the very general point of matching the method to the size of the harm. I would like very much if we could actually inform this whole practice more by publishing how we got to numbers when we reached numbers. I mean, these days you go to a damage assessment report and it talks a lot about the background and what happened. And you get to, and so it was this much money and there's this gigantic gap. If we could more fill in the beginning, the middle, and the end, then we would have a place to start from for every case that was kind of complete. And then we could ask, well, what are we missing in this case? And just fill in those precise gaps and identify what they are and their importance. But we kind of start fresh each time, which is crazy. And we don't have our history written across all these cases that we could draw on to make this much more efficient. So I think there's a variety of things that we can do to lower the costs and enhance practice. And we're just kind of not doing it.
We do have certain database material, which maybe will come up in the next panel as well. NOAA has some data, DOI has some data. The group has had a database since day one. And our biggest frustration is that when these wonderful tiny or bigger or middle cases settle, that we're able to catalog certain information, but that the details of settlements are often just not discussable. Companies don't want to discuss them. The government doesn't want to discuss them. So maybe we try to change that or see if we can change it to, and also we have in the standing committee, we have a restoration catalog and we have some tools which are intended to not have people reinvent the wheel on certain aspects of doing this. But, a lot of food for thought here in terms of what would really be useful in terms of, as I say, broad methodological approach versus tools for site-specific cooperative, ideally, resolution. So, I thought of his name, Joe Stiglitz. He was who came and talked to us. Yeah, we've had quite a litany of people who've come over the years. So that was interesting.
So I think, didn't we have another question back here? Did we have
4
one?
more minutes.
Okay, so let me pose hopefully a quick question. Let's see, what was I thinking of here? So we've talked about several issues today: climate change, shifting regulatory frontier, emerging contaminants, international synergies, and so on and so forth. And among those influences, which do we think are the most challenging to our current process of liability assessment and restoration planning? Those kinds of current issues. Volunteers on the panel, I think I see those.
I'll start it. I think emerging contaminants is probably the most challenging, followed closely by climate change. But the emerging contaminant issues were, the concerns within stakeholders are far outstripping our science right now. We don't even know the risk yet. But so it gets back to, I think it was Charlene said that we're having hazard and risk being equal, and we're taking out exposure. And so that's, I think, the big issue. And I think the complexity of climate change is really, makes it a close second. If it may be ahead of it actually, but I think with emerging contaminants, it's hard to address issues, fill the data gaps if you don't even know the questions yet.
Well, of course, EPA's quantitative risk assessment guidelines have pathway analysis explicit. Problem is, it's in the public psyche, equating hazard with risk. I think that's the difficulty there.
Yeah,
Yeah.
and it's hard to argue when someone's, fearful that,
Right.
and they don't understand that, you can have a low concentration and a high exposure, and that could be more toxic or more problematic than a high concentration and almost no exposure.
Public
It's really
perception,
hard
yeah.
for the public to understand
Right.
that.
That's exactly right.
And then we complicate things by making everything an inverse relationship. So as the number gets bigger, it's less toxic.
Well, to be continued. We're very open, by the way, to posting resource materials of anyone who wants to suggest a resource material for mutual reading. We're happy to post that on the meeting website. So I just wanted to mention that. This was an excellent panel, excellent discussion. Sometimes I feel it's overwhelming because I convert this into a to-do list and it's like gigantic, but try to keep it small. We are going to ask people following the meeting to do an evaluation and also some thoughts about the issues discussed and how we carry some of that forward. So we have some multi-stakeholder working groups and that might be one mechanism, but we'll talk about other things. But John, Ruth, Ted, excellent job. Lauren, David, Bill, Al, thank you.